Well, thank you. The floor is actually in my office in Berkeley, California, and I'm delighted to be with you. And I'm very grateful to the university and Professor Pinotti for inviting me to participate in this way. I'd much rather be with you there in Milano, but this is the best we could come up with. I thought that I would mention some features of the asylum and refugee system that you probably know about, so I risk boring you with the material with which you're familiar, but I think there are a few features of the system from the legal point of view that bear mentioning, and I'm happy to elaborate on them later on if you wish, but I assume that they are basically familiar to you, and so I won't take very much time to present them. The first is that the refugee definition was developed and promulgated under the Convention and Protocol of 1951. So it was based on a post-World War II model, and is obviously anachronistic in a number of ways. The key concepts from a legal point of view are that the asylum and refugee applicant must have a well-founded fear of persecution on the basis of race, religion, national origin, political opinion, or membership in a social group. Now, I mention these in part because they're not very well known to most people who hear about refugee policy. There's the general notion of persecution that has certainly penetrated the public mind, but it has to be a persecution of a particular kind. On the 5 bases, one of the 5 bases that I mentioned: race, religion, national origin, political opinion, or membership in a social group. And the courts have elaborated what those terms mean, but the bottom line is that there are many people, perhaps most people, who are considered refugees by the general public and by the media, who are not, in fact, eligible under the law governing the refugee system, because although they are suffering terrible injustices and painful conditions, they may not be persecuted so much as they are fleeing those horrible conditions. And if they are persecuted, they're persecuted on the basis of some other characteristic than the ones I mentioned. So that's the first point. The second point is that the refugee system is one in which the states make their own determinations as to whether a particular individual is eligible for the protected status. So there's a strong disincentive to find refugee status on the part of any particular state unless it is proceeding on a humanitarian basis. And although humanitarian motives are certainly important in this area for many states, not all states, that is the right of the state to make its own determinations. UNHCR cannot second guess the state in this respect. So it puts UNHCR in a very difficult position. Now, some states have delegated their authority to make these determinations to UNHCR, but many have not. The United States certainly has not. Why do states resist acknowledging the refugee status of individuals? Well, I think we know from recent events what most of those reasons are. It's costly to them. There's often violence in the refugee camps. Domestic politics are extremely volatile based on this, and we've seen this in Europe, obviously, in recent months and years. There's a lot of poverty in many of these countries, and there's resentment on the part of the natives of the countries of refuge, that the refugees might even be treated more generously than the nationals of those countries. And there are foreign policy risks, obviously, for countries that accept a large number of refugees or reject a large number of refugees. So that's the second point. The third point, legal point, is that the state's only obligation under international law is non-refoulement. That is the obligation not to return individuals to the conditions of persecution. This is a very minimal protection. This is simply the right to. This is the right to reject their claims for social benefits beyond a bare minimum, and the right to refuse to give them legal status other than this minimal protection. And even this obligation of non-refoulement is not enforceable. So it's important to recognize that the state's obligation with respect to refugees under the law is very, very minimal, simply non-return. It's not to accept them and to integrate them into their societies. The problem, as we know from the conditions in Europe recently, is not just a human rights problem, it's a geopolitical problem, as states perceive that refugee flows create grave threats to their national security and even to peace in the region. So, with that background, I proposed an analysis of what the responses to this situation might be, and I offer one of my own. There are four broad strategies that states or groups of states might try to promote in the face of this condition. The first is, and obviously the most attractive in theory, is to eliminate or prevent the root causes of refugee flows, which we know are political, economic, environmental, military, and cultural. They're very, very complex forces that are animating these flows. This is extremely eliminating or even reducing these root causes is obviously very hard to do, especially in the short run, but even in the long run. In addition, some welcome developments, such as liberal democratic revolutions of the kind that we saw initially in Egypt and Libya, putting aside what happened in the wake of those revolutions, increase refugee flows as well. So even conditions that we might welcome are likely to produce flows to other countries. And the other reason why this root cause strategy is unlikely to be successful is that, at least in the short run, and I think perhaps in the medium run as well, is the principle of national sovereignty, which limits outsiders' right to intervene to try to alleviate some of these conditions that promote refugee flows. So that's the root cause, what I call the root cause strategy. A second strategy would be to repatriate refugees to their own countries as soon as possible. This is very hard to do, obviously, until the conditions that led to their migration stabilize. It's unsafe to do so, and perhaps inhumane to send them back. They also don't want to return for a number of reasons, including fear of reprisals by the groups that caused them to leave in the first place. The dominant regime in their home state expropriates their property such that they often do not have any place to return to. And their condition obviously is extremely perilous to be in the event of return. A third strategy is temporary protection, but there's a serious credibility problem that prevents temporary protection from being as useful as it might seem in principle. First of all, the temporary tends to become permanent. There are many examples of this. Perhaps the most dramatic one is Palestinians in the Mideast who have been treated as refugees in what was hoped to be a temporary condition and is now going on 70 years. This is also true of Salvadorans in the United States who are accepted as refugees and asylum entitlements, and on the assumption that they would be returned once the conflict in El Salvador abated, and that did not happen. So assuring temporariness is very difficult. One strategy for assuring that refugees will go back voluntarily is to discourage their integration into the community. That is occurring in Europe, and it's obviously a very harsh tactic, and one that humanitarians are going to resist very much. So that's not a terribly useful strategy in practice, which leads us to the fourth strategy for alleviating the problem, and that's the one on which I want to focus, resettlement. Now, this is most costly, and it's the least desirable. It's really a last resort. The U.S. resettles about 100,000 people, more or less, each year from who they deem to be entitled to asylum. Canada resettles a lot. Sweden, Germany, in recent years, has been very generous in offering resettlement. There's great domestic resistance to this, as is obvious, and indeed the resistance to this is what presumably has occasioned the convening of this conference and many other conferences of this type. Some states, like Japan, don't resettle anybody, but they provide money and in-kind material, such as medical supplies. I believe that the only way to resettle a larger number of refugees is through burden sharing. And in principle, of course, the states in the EU have accepted that principle, but they have, as you well know, and as you presumably discussed in this conference, been unable to come up with a burden sharing mechanism that can overcome the political objections. So here's my proposal. First of all, there needs to be an international agreement to the norm of burden sharing, to the idea that burden sharing is not only a legitimate, but from a humanitarian point of view, a mandatory obligation of every state. Every state has a presumptive duty to assume a burden that is proportionate to its capacity. At the same time, it's essential to continue to press for prevention, repatriation, and temporary protection, the more desirable of the four strategies that I mentioned earlier. So first, there has to be an agreement to the norm, and second, an international agency, could be a regional agency, but it also could be UNHCR or some other mechanism, must be tasked with allocating quotas to each participating state, and to certify when each state's burden has in fact been discharged. Now, how that burden is to be allocated, how these distributional decisions are to be made is obviously subject to negotiation, but I think they can best be based on a state's assimilative capacity, which will generally relate to its landmass, its population density, its ethnic heterogeneity, and of course, its wealth, as well as historical factors. So those are criteria for allocating burdens under this scheme. There would be exceptions, such as the exception for a state that is involved in a civil war or some other natural disaster, which would reduce its capacity to absorb refugees. So with those quotas having been allocated among the states, states would be able to buy and sell their quota obligations from one another. This is really a market in the obligation to protect. The idea of the market is, as economists don't need to be reminded, but it bears repetition, the market makes a virtue of the otherwise regrettable international inequalities that exist. The fact that states differ with respect to their resources and their willingness to take refugees. So, Russia, Brazil, Mexico have lots of room and some tolerance for minorities, but they need money. Japan has lots of money, but no room or tolerance for ethnically diverse refugees. The US, Canada, Australia, and perhaps some EU countries have both. They have both the resources and the capacity to absorb. So the notion of a market makes both states better off, given their initial burden-sharing obligation. That's, of course, the constraint against which these changes need to be measured. The agency, the international agency, would regulate the market, and it would supervise trades. It would impose and enforce minimal standards of decency in the treatment of refugees once they have been allocated to a particular state. The agency might impose certain constraints on the market. So here are some issues that need to be resolved. Should a state have the right to know which particular refugees are in its quota or in the quota of states with which it is considering trading its quota? Or must the trading be blind with respect to religion, nationality, ethnicity, and so forth? That's not an easy issue, and the way in which it would be resolved would affect the willingness of states to participate in this sort of system. And there are arguments, I think, on both sides of that. The trade-off between a non-discrimination principle and the desire to maximize the number of refugees granted protection is a very difficult trade-off. And it's my contention that whatever one's objections are to this kinds of market scheme that I'm proposing, compared to the status quo, it is desirable. So yes, it's true that refugees under my scheme would often not be sent to the countries in which they would like to live and in which their relatives may already reside. But on the other hand, more people would receive protection. Another difficult policy issue under such a scheme is that the situation as to what occurs when refugees are assigned to a particular country but not yet resettled there. So you could allow them to engage in constrained trading among the refugees themselves with respect to the destinations that they would like to be protected in. There are a couple of analogies to this sort of scheme, which I'll mention very briefly. You may be familiar with the ones in the United States, or you may not. In New Jersey, under a court decision by the leading court in that state, regional contribution agreements are allowed to discharge the fair share obligations of the municipalities in the state of New Jersey with respect to providing affordable housing. This followed, as I said, a very important Supreme Court decision in New Jersey, which imposed fair share obligations to construct affordable housing in their communities. And some communities needed the money, and other communities had the money, and they were permitted to engage in trades for those obligations. Second, under the Clean Air Act, a very important statute enacted in 1990 in the United States, emissions trading is encouraged. it depends obviously on the initial allowances to pollute, which then can be traded among different polluters with the hope that the low-cost polluters will be able to sell their pollution control obligations to those that are that can only prevent pollution at a much higher cost, so that the low-cost pollution opportunities will gradually filter through the jurisdiction. In some international environmental accords, burden sharing and trading is authorized as well. Now, there are four main objections to this sort of scheme, and I want to face them squarely. The first is that states won't agree to this scheme, and obviously in Europe that seems to be the case. The states have, in many cases, accepted the burden sharing idea, but they can't agree on how to allocate them. So that's a fundamental political objection. And to overcome their resistance, the U.S., Canada, the EU all need to use their trade benefits and their political and other kinds of muscle to extract agreements and to enforce this kind of regime. So it does require political intervention and carrots and sticks for states to reach an agreement. I regard this sort of policy as a kind of catastrophic insurance policy against a flood of refugees reaching any particular country. So the idea is that a country should be motivated to agree to a scheme under which it will receive a relatively small number of refugees in order to avoid the risk that they will be deluged with a very large number of refugees in the absence of such a scheme. And in the integrated world in which Europe exists, the proximity to the sources of refugee flows make that concern about a catastrophic, what states would regard as a catastrophic flow, is a real one. There are strategic impediments to such a scheme. The problem of securing agreement obviously is at the heart of it, and it depends on creatively deploying political, economic, military, and moral influence to overcome that sort of resistance. A second objection, it has to do with the practical problems of implementation. I've already alluded to some of them. There are many others, and the response to that is that we simply must do the best we can. The alternative is to do nothing, and that is, at least morally, unacceptable. A third objection is, and this is a common one, is that such a scheme would be treating humans like commodities. This is called the Commodification objection in the United States. One analogy to this objection is that in the environmental area, there are critics of such schemes on the grounds that it would give companies a license to pollute because they would be purchasing the right to pollute from other polluters. And I think that's a very weak objection to emissions trading. I think the economists in the audience will certainly appreciate why that is. Still, monetizing the obligation to protect refugees will strike many people as inhumane, when in fact it is designed to increase the level of protection that is afforded, a humanitarian goal. So the answer to this objection against to commodification is that it will maximize the level of protection, just as in the emissions trading schemes in the environmental area, it maximizes environmental protection. The number of units of affordable housing under the New Jersey scheme I mentioned before have increased compared with the absence of such a scheme. And in the same way, the number of refugees receiving protection would increase. These are all profoundly human moral goals, and we ought to recognize the trade-offs as they exist, and accept the legitimacy of these concerns, but devise the best scheme we can in light of them. Another objection is that if states know that refugees have someplace else to go, they may increase their incentives to generate refugee flows to get rid of unwanted people. This is a extremely distressing motivation. We've seen it in certain areas, but the response to that is that this scheme that I'm proposing does not increase that incentive. Their incentives to get rid of unwanted populations through one means or another is already strong. And this scheme, I think, would simply recognize that and try to make a virtue of necessity in dealing with this in a humane and effective way. Thank you.